There is no audio. Hello, Ashish ji, you are on mute. We can't hear
Um,
you.
sorry, some issue. Okay, can you hear me now?
Yeah, now you are.
Okay. Sorry for this. Okay, so I started off saying that the way the presentation is structured is I will take you through brief overview on the banking laws and then speak on the interplay between the banking laws and some related laws and some circulars of the regulator RBI. And when we are discussing each of these topics, a lot of case laws will also be discussed, and then in the session with some key takeaways. Okay, go ahead. So IBC doesn't need any introduction as such. However, just to put down the broad objectives of time-bound recovery, resolution, maximization of the value of the assets, promote entrepreneurship, and balancing the interests of all the creditors and the debtors. And one of the key features which where we'll see an interplay is one is section 14, the moratorium, which becomes applicable when insolvency starts, and section 238, which is the non-obstant clause, which ensures that the provisions of IBC will prevail over any other acts, and wherever there is an inconsistency, IBC will prevail. Otherwise, if there is no inconsistency, then the acts will work in harmony. Now, just to give some background on the challenges and the acts earlier, while these acts are still there, and IBC is an improvement over the earlier recovery acts. The RDB Act came in 1993, and this was amended, and it was a major reform in the 1990s. And we are all aware that the NPAs had surged a lot, and the DRT was constituted under this act. And the idea initially was that the DRTs would act as a mechanism to resolve the stress assets quicker. However, the process became very slow, and hence further reforms were needed. SURFACE came into being in 2002, and section 13 subsection 4 of SURFACE Act gave the right to the lenders to possess the secured assets without resorting to going to the courts. And a 30-day notice was given to the borrowers, post which the asset could be auctioned, and the borrower then lost his right to of redemption of the asset. However, this also faced a lot of challenges, and the process, there were some valuation disputes, borrower would obstruct, which is the case in IBC also. But under SURFACE, this became more pronounced, and hence the requirement was felt to have a unified act which would address the stress assets and will act as a mechanism to bring in all the stakeholders together and provide a window clearance kind of a thing. And the key insights are that these acts, pre-IBC recovery mechanisms were fragmented. They were debtor friendly rather than creditor friendly, and they were driven more from an enforcement or recovery perspective than an overall resolution for all the stakeholders. So some statistics, of course, the latest statistics might be a bit different. The recoveries under Lok Adalats, DRT, SURFACE, and IBC. IBC recoveries are much more than those under the earlier acts. However, the recoveries earlier under IBC, they have been falling. So that's however, it remained about 28.3 percentage in 23-24. We come to the banking laws. So the banking laws form the basis of a legal and regulatory framework which governs the functioning of the financial institution, banks, and how it interacts with the borrowers, depositors, regulators, the central government. All that comes into this fold. Now let us take the key acts one by one. The RBI Act 1934 that constituted the Reserve Bank of India as the central monetary authority, which would regulate the financial system, and the objective is to provide stability to the financial system. And the one of few functions of RBI or the key duties are to control the currency issuance, credit flow, and the monetary policy for stability. So economic stability remains the underlying. Then we came in the Banking Regulation Act 1949, and which was subsequently amended also to give more powers to RBI to direct the banks to initiate insolvency. This act governs the licensing, functioning, and the supervision of the banks. In essence, it lays the framework under which the RBI would function, and it empowers RBI to regulate capital adequacy management, mergers, and the such other things. Then we had the RDB Act 1993, which is put in as the fourth number here. And under the RDB Act, DRTs were established for speedy recovery of debts which were owed to the banks and financial institutions. It covered both secured as well as unsecured debt and provided a legal mechanism to claim their debts or to enforce the debts. 2002, we had the SURFACE Act, and that allowed banks to seize the asset and enforce the security without going to the courts. So the idea was that if we are not going to the courts and there is a mechanism, it would be a faster mechanism. However, SURFACE Act also had its drawbacks. Then an underlying banking act is that of the Negotiable Instruments Act, which governs the issuances of instruments like checks, promissory notes, bills of exchange, and it regulates their use, transfer, and the idea is to have a very stable underlying commercial system, and hence you have the section 138 of dishonor of checks, whereby a criminal liability is there or if a check has been dishonored. And the idea is to have a strong underlying commercial payment system. Then under these acts, you have RBI directions and circulars which are issued from time to time, and the banks and the financial institutions are obligated to adhere to these circulars. These circulars would also govern how the assets have to be, the provisioning of the assets, classification as a willful defaulter, fraud classification, all those things come under these. Now, let's start with interplay of IBC with the RBI Act 1934. The 1934 Act of RBI was to, as I mentioned, was to establish RBI as India's central bank, and it provided a framework to regulate the currency, manage the credit system, have monetary policy, and supervise. The supervision is also one of the key things of under RBI's duties, and it would act as a banker to the government, and it's a banker of the last resort. If there are, it is empowered to carry out market interventions to maintain the stability. Uh, the RBI Act empowers RBI to supervise, regulate that I covered. So it covers both banks and financial NBFCs also. And it also, RBI has the power to supersede the board if it finds any misgovernance. Then it can supersede the board, like what happened in case of DHFL. RBI has a role in initiating the IBC proceedings. Both this Act, RBI Act 1934, 1949 Act, they work in tandem with IBC, and there is no conflict as such. If I take the analogy of geopolitics, probably it is like India and Russia relationship, which works in tandem, and it is never at odds. So RBI's rule in initiating IBC proceedings is that RBI can direct a financial service provider, initiate insolvency against a financial service provider, and the administrator can be appointed. We have seen cases like DHFL, Reliance Capital, Sri, where these financial service providers were put under IBC. And there is a specific mechanism which drives this, where the moratorium is imposed, interim moratorium is imposed right from the filing stage itself. And there are some specific rules for financial service providers, like the FSP rules. So the broad objective of RBI to maintain a financial stability is being enhanced, or there is a synergy between IBC and the RBI Act, whereby the regulator identifies the distress financial situation, and then they would direct the banks to undertake certain actions. Now, the interplay of IBC with Banking Regulation Act 1949. The main purpose of Banking Regulation Act 1949 is to regulate the business of banking in India, and it ensures the safety and soundness of the banking system by protecting depositors' interests, and it promotes a stable banking system. RBI's authority, the 2017 amendment, which I spoke of, introduced another 35 Act, where it gave authority to RBI to direct banks to initiate insolvency proceedings for specific defaulters under IBC. Under that, circular came in. Of Feb 2018 circular came in, and then the Dharni Sugars case happened, which whereby the circular was struck down. So we will cover that a bit later in the presentation. The IBC, as we know, focuses on putting back the corporate debtor on its feet through resolution. And this goal aligns with the Banking Regulation Act's objective of ensuring the safety and soundness of the banking system. And IBC provides a framework which helps the banks recover their dues and minimizes the losses. So these two acts also work in tandem, and there is no conflict or discrepancy. Uh, okay, let's go ahead. So some case laws, Dharni Sugars, as I had mentioned, RBI circular of Feb 2018 mandatorily requires the banks to refer the cases where there were defaults over 2000 crores to IBC. However, this case was challenged by the borrower, and the key points of the challenge were that this had to be first authorized by the central government, and it cannot be a blanket order, and it has to be for only specific cases of default. So this 2018 circular was struck down, and all any action taken against this under this circular was held to be ultra vires, and any action taken by the bank was held to be null and void. So banks had to resort to a fresh filing of cases. The key takeaway from this Supreme Court order in the Dharni Sugar case was that RBI's power under the Banking Regulation Act, they are not absolute, and so all the procedural things also have to be followed to the T, and only then the powers become absolute. And IBC can be triggered by RBI only on a case by case basis with the government sanction only, which has been stipulated in 35A. Just go back. I think there was one more case. Yeah. So here, when a DHFL case, RBI exercised powers under Section 45 IE of RBI Act to supersede the Board of Directors of the NBFC, and administrator was appointed. When the CRP commenced, the directors sought powers or sought their rights to attend the COC meeting, get the minutes, get the resolution plan, as is the case with the companies, usually the corporate debtors which go under IBC, the suspended board of directors get these rights. So the issue which was involved in this case was, does RBI supersession of directors confer the same rights to the directors as the suspended board of directors under IBC? NCLAT and then later, so NCLT later NCLAT held that the superseded board of directors will not get, of these financial services providers, will not get these rights, and they lose all the rights of attending the COC meetings, getting the minutes, etc. So the key takeaway is that so any supersession under RBI Act is much stricter than IBC suspension, primarily because that the underlying is maybe misgovernance, and that is the reason our the directors who are superseded board will not get the same rights as the other companies under IBC. Now we come to the interplay of IBC with SurfAC Act. The purpose of SurfAC Act 2002 was to provide a quick and straightforward method for banks, financial institutions to recover their loans by enforcing security interest without court intervention. And this was primarily for the benefit of the banks and financial institutions. So it did not encompass covering the other creditors. So it was only for the bank's benefit. And the process which was involved was that secured creditors would take the possession, issue a notice, and then issue a notice to the borrower, give them 30 days time, and then the property would be put up for auction to recover the dues. And the recoveries which happened, they had to follow certain distribution pattern, and primarily the funds would go to the financial creditors. Here, of course, no funds would go to the operational creditors. When I said primarily to go to the financial creditors, is because if there were any workmen dues, those would have to be given priority. The limitations were that it was not very effective in solving very complex insolvencies where there were multiple stakeholders. This was more for the benefit of the financial creditors, and it started taking a lot of time. There were a lot of litigations, and hence the recoveries under SurfAC Act saw a beating, and it went down. Now, there are certain points where, because SurfAC is an act, is also a recovery mechanism. IBC is a resolution mechanism which also involves recovery. Certain key points which come forth are whether when there is a pendency of proceedings again under IBC, DRT, or any other acts, if whether a financial creditor is prohibited from initiating proceedings under IBC. So, whether that results in a forum shopping, can you initiate multiple actions? That is one of the key points which has been addressed. Uh, Section 238, as I mentioned, it's a non-obstant clause, and it will prevail over the provisions of SurfAC Act wherever there is inconsistency. So that position stands with respect to any act, including SurfAC. When an auction was conducted under SurfAC and the auction process is not complete and CRP proceedings are initiated, does the auction process under SurfAC get stalled automatically or through court intervention? That is also one of the key points which came up, and that has also been addressed. However, there is a recent ruling by the Honorable NCLAT, and that seems to be at a bit of a divergence from the established position. we'll cover that. Uh, Now, another key point is that under liquidation, um, a secured creditor has two options. You can either relinquish your security to the liquidation estate, and then once the liquidator sells the assets, under the waterfall mechanism of Section 53, the distribution happens. Or under Section 52, the lenders can choose to enforce the security by themselves. When they choose to enforce the security by themselves, are they required to contribute a proportionate amount towards the workman's dues? Or and the liquidation costs. So there is a recent judgment on this also. That's good. Moratorium and what has been its impact on SARFAESI and security enforcement. So, Section 14 we are all familiar with, and that prohibits any action to foreclose, recover, or enforce any security interest created by the corporate debtor. Now, this security interest is very critical. What all falls within the definition of security interest? If an action has already been taken by the banks in terms of possessing the asset under SARFAESI, does it amount to a security interest getting transferred before the insolvency date or not? I think the judgments on this are very clear that mere possession does not amount to transfer of ownership, and hence any action which was done under SARFAESI and which is pending will have to be stopped when CRP starts. And so the purpose of Section 14, of course, is to preserve the asset, and it's like when a patient is admitted into an ICU, he is insulated from the external environment, and so which would enable a quick recovery. The key aspects of SARFAESI Act are that 40, Section 14 specifically bars any action, any security. Simultaneously, both SARFAESI and IBC cannot proceed. Any action taken under SARFAESI now stops, and in the moratorium declared by the adjudicating authority from the insolvency date, it typically is from the ICD to resolution or liquidation. So no action can happen therein. And Section 238, we discuss that it has an overriding effect. Yeah, it's So this is one of the points which came up. Can NCLT set aside an auction conducted by a bank under SARFAESI Act 2002 when the auction notices under Section 13(8) of the Act were issued prior to the commencement of CRP and the sale was conducted prior to that? Now the key point is, when does the sale get conducted? In a case decided by Supreme Court, it is held that the sale gets concluded when the final amounts are received, and then the sale certificate is issued. So till that time, if within that period, if insolvency gets initiated, then the action under SARFAESI has to be stopped. However, in this case, this seems to be at a slight divergence. This was the NCLAT judgment in case of Nagpur Nagrik Sahakari Bank versus Mohanlal Pillai and others, where NCLAT held that a bank auction initiated by issuing Section 13, Subsection 8 SARFAESI Act notices before CIRP cannot be set aside by NCLT because CD's right to redemption is lost upon the issuance of public auction notice. So the 30-day notice was issued and the public auction was conducted in this case, and the sale was concluded. The NCLAT emphasized that the sale had been completed before CRP, and hence the moratorium would not come into effect. Moratorium which has come into effect will not have a bearing on the sale which already happened. And but this was similar to NCLAT's ruling in Pratibha Industries. We discussed this that pre-CRP action, what has happened, loss of right to redemption and the finality of auction. When does the auction finally get concluded? That would be the key determining point in deciding whether SARFAESI continues or does not continue. Another key aspect is whether there could be simultaneous proceedings of insolvency. Section 7 can be initiated while the recovery proceedings under other acts is ongoing. As I think the judgment on this and the jurisprudence is very clear that the pendency of proceedings again under any of the acts like SURFACE, DRT, or Prohibition of Benami Property Act will not prohibit the financial creditor from initiating proceedings under IBC. However, once the proceedings under IBC have been initiated and the corporate debtor has been admitted under insolvency, all the other proceedings will come to a standstill with respect to the corporate debtor only. With respect to the guarantors, the actions can continue. There is a case law of NCLAT Chennai in case of Amar Bora versus City Union Bank, which explicitly held that a financial creditor can file an application under Section 7. This is one of the judgments. There are many such other judgments. Say that a financial creditor can file under Section 7 of IBC even when the proceedings related to the same debt were pending before other forums. It would not lead to forum shopping because IBC prevails over the other acts. We discussed this that NCLAT rejected the argument of forum shopping in emphasizing that parallel proceedings can continue and proceedings under Surface and DRT will not extend the limitation period. There is a limitation period for filing application under Section 7. However, the proceedings under Surface DRT will not extend the limitation period. A secured creditor has two options, as I mentioned, under Section 52 or to relinquish security interest, and then the liquidator enforces the security, sells it, and distributes under Section 53. If a secured creditor chooses to realize the security interest under SURFACE Act when opting for enforcing taking recourse to 52, opting out of the liquidation estate, is he required to contribute a proportionate amount towards workmen's dues? So this was held in the affirmative in case of Cosmos Cooperative Bank case versus the liquidator of Pandit Automotive. NCLAT ruled that secured creditor will have to make contribution, proportionate contribution towards the workman's dues. And this arises from the interplay of Section 52 of IBC and Section 13, subsection 9 of the Surface Act, and also Companies Act, because under the Companies Act, it is prescribed that the workman's due, when you enforce action against under Surface Act, will have to be paid out first. So we discussed this that the distribution proceeds must be done in accordance with Section 326 of Companies Act, which provides for payment of workmen's due on a preferential basis. Uh, the statutory obligation will not of the lender will not disappear because the bank used Surface to recover its debt. So there is an interplay of IBC, Surface and Companies Act. So because there is no dissonance or disharmony in this particular case, then the lender has to make the required contribution. And Section 53 will not be applicable in this case when you opt for 52. Under 53, there is a mechanism which has been prescribed, and that wouldn't be applicable. Liquidation, it was also, interestingly, it was held that while the lender has to contribute towards proportionate share of its workmen's dues, the NCLAT NCLT had ruled that they are not obligated to contribute towards the liquidation costs. and this was upheld by the NCLAT. Now, this becomes a sore point because if the lender does not contribute to the liquidation cost, who would bear the cost? So that remains an open issue, and I guess the subsequent amendments or the jurisprudence which gets developed further will address this issue also. Section 238 of IBC we discussed, and that will so there's a repetition that will prevail over any provisions of IBC if it is inconsistent. And an important case in case law here is Encore Asset Reconstruction Company versus Charu Desai and others. The facts in this case were that the corporate had defaulted on a loan, and a banker had initiated SURFACE and took possession of the mortgage property, and CRP began, and IRP sought control of the assets which were under the possession of the banks. And the NCLT ruled that the banks must surrender possession to the IRP, which led to an appeal by the bank in the NCLT. And NCLT ruled that because of Section 238, it has an overriding effect. And IRP has one is the moratorium, so any recovery proceedings get stalled. The second is also related to Section 18 of IBC, whereby one of the key duties of the RP, sorry, is somebody saying something? Is there any question? Sorry, I'm not able to hear. I guess seems to be some mistake. Okay. So under Section 18 of IBC, the resolution professional is duty bound to take control and custody of the assets, and hence he is obligated to, if the possession is with the banks, the possession does not mean that the title has transferred to the banks, and hence he is entitled to take the possession. The ownership rights have not got transferred. This another case in case of Indian Overseas Bank versus RCM Infrastructure, where the Supreme Court held that once CRP gets initiated, moratorium starts, bank cannot continue the proceedings under SURFACE to recover the security interest of the corporate debtor. And uh, this is, I think we have covered this aspect, and so okay, let's move forward. Just go back. So one important point, this what I mentioned is the timing of the sale completion is very important. So let's say an action has been taken under SURFACE and the sale has been concluded. At what stage does the sale get concluded is very critical. And I think because of the recent NCLAT judgment, this point has kind of become open again on when the sale gets concluded. Though it has been so far held that the sale gets completed only upon the full payment, there is another school of thought and some arguments saying that only the administrative aspects are to be done, and the title has passed and substantive portion of the sale is complete, then it should be held as held that the sale is complete. So this point also needs to be addressed in future. The interplay of IBC with RDB Act, I think we discussed this. This is similar to what is there under IBC. Section 14 moratorium comes into play, and Section 238. Because of Section 238, this has primacy over the RDB Act. However, there doesn't seem to be any sort of dissonance, discrepancy between IBC and RDB Act as such. And there is a unified forum which has been created by IBC. So if there is any action which has been taken under RDB, that IBC can IBC can surely be initiated even though the action is pending. So the same principle is there here also. Another case where the financial creditor filed a Section 7 IBC petition while the corporate debtor was challenging its NPA classification before the DRT. And the issue involved was, does a pending NPA dispute before DRT, whether that would bar any initiation of CRP under Section 7. And it was held that the recovery action or pending action against DRT proceedings will not block admission of a Section 7 petition. The key aspect of determining a debt and a default, once they are established, then the admission has to happen. And the key takeaway is that the IBC is supreme, and it overrides other acts where there is inconsistency, and parallel actions can be initiated. Now we come to the interplay of IBC with the Negotiable Instruments Act. The Negotiable Instruments Act, one of the oldest acts, it governs the negotiable instruments like check, dishonor, promissory notes. While IBC provides for a framework for resolution of financial distress through starting with an interim moratorium. The key conflict which arises is whether IBC moratorium would stop the Negotiable Instrument Act proceedings under Section 138. And it has been, there have been several judgments, and it has been amply clarified that IBC moratorium will not prevent any criminal proceedings against Section 138 of the Negotiable Instrument Act. So there are two parties, the corporate debtor and the employees or the directors who have issued the check. So the while the action against the corporate debtor has to stop, the action against the directors or the employees, that can continue. So that is the established position. Even if the underlying debt gets settled, these actions can continue because they are criminal in nature. And while the recovery has happened, Section 138 criminal liability that aims to punish the acts of dishonesty, and the idea is to maintain the commercial trust, not just of course recovery of debt is one part. However, the intent is to punish any criminal activity so that there is trust in the financial system. Now, the conflict we discussed whether a check bounce case can continue, and Supreme Court stance has been very clear, and that has laid down the law that IBC moratorium will not prevent any action against the directors, even post moratorium. Rakesh Bhanot versus Gurdas Agro Private Limited, Supreme Court of India held that the moratorium under Section 14 will apply only to civil proceedings, not to criminal cases. And even the approval of resolution plan will not absolve the personal liability of directors for dishonor of the check. So but the directors cannot argue that by virtue of approval of the resolution plan, the debt has been settled, and hence their liability should end. The criminal liability will continue. Even the liability to pay the balance portion of the debt also continues, and that position also has been very well established. Okay. There's certain other acts like the Companies Act, which remains the backbone of governance. And while the banks are regulated by the Banking Regulation Act, corporate identity still gets shaped by the Companies Act rules. So, and there are certain, as we discussed under Section 52, when the lender opts to recover assets under SARFAESI, this comes into play, and hence there is an interplay between in this aspect, at least, there's an interplay between the Companies Act, IBC, and SURFACE. Indian Contract Act, that is the root of every loan. So any banking transaction which happens, any guarantee, any loan documents, indemnities, all those, they are essentially contracts. And the Contract Act remains at the root of all actions which are taken. And regarding the security amongst security intercreditor arrangement in terms of security, the position is not that well settled under IBC. We will be covering that aspect also. Uh, Wherever FEMA Act is applicable for a company under IBC, so they have to comply with that. IBC cannot become a shield for not doing the compliances. Though any non-compliances which have happened in the past, the RP can take a stand that is not responsible for those. However, and he's not obligated, though he can make the best effort, he's not obligated to correct those non-compliances. However, during the course of insolvency, he has to ensure that FEMA is also complied with. Yeah, let's go. We spoke on the interplay. Now, there are certain important points and practical aspects which come in when the insolvency starts. So, regarding the guarantees, and the key point which was earlier debated a lot was whether enforcement of a guarantee, invocation of the guarantee gets hit by moratorium, whether it is a security interest, and because that has a negative impact on the resolution. Earlier, courts used to grant an in the injection or a stay on the invocation of guarantee. Uh, However, subsequently there have been amendments, and the jurisprudence has laid down this that a guarantee invocation is a separate thing. It will not get hit by the moratorium because it is essentially a contract between the beneficiary and the bank, and hence that contract has to be honored. It does not affect the corporate debtors assets as such. So when we say the asset, the margin money also comes into play, and we will be discussing that also. The other point is regarding classification of fraud during moratorium, whether the corporate debtor can be classified as a fraud during moratorium. That was also a point which was not very well settled, but I think with the Rolta judgment recently of NCLAT, that position has also been settled. Similar thing with classification of the company, the promoters as willful defaulters, whether this has an impact on the resolution process, that also we will discuss. The invocation of personal guarantees, corporate guarantees, when the resolution plan settles the debt, and that position is also now very well established, that personal guarantees and corporate guarantees, they can be enforced simultaneously or post the resolution, and the liabilities of the guarantors does not extinguish by virtue of the resolution plan getting approved. Uh, and that flows from the Contract Act. Writ petition, when the company is under IBC, writ petition is maintainable in the Supreme Court or High Court. So we'll cover some case laws here also. And what are the other powers of central government and RBI under the FSP rules 35 AA Banking Regulation Act? What we just spoke of earlier, we will be covering that also in a bit of a detail. Invocation of guarantees. The guarantees typically could be performance guarantee or financial guarantee. These are the definitions which are just laid down. A performance bank guarantee is a financial instrument issued by a bank ensuring that a contractor or supplier will fulfill their contractual obligation in terms of the performance. and if they fail, the bank will compensate them for the guaranteed amount. So bank will pay if the guarantee is invoked. A financial guarantee is bank's formal promise to pay a third party beneficiary if the customer fails to meet a specific financial obligation, such as loan prepayment or any advance taken for goods services. So bank acts as a guarantor and they will make good the payment if the guarantee is invoked. Uh, Whether guarantees can be invoked during CRP? Yes, guarantees can be invoked during CRP, and the moratorium under Section 14 applies to the debtor's assets. And there's a bar on the legal proceedings against the corporate debtor, but this will not impact the bank guarantees, which are independent contracts by themselves, contracts between the bank and the beneficiary in whose favor the guarantee has been issued. Since these guarantees are unconditional and irrevocable, the beneficiary can invoke them. And the liability of this is with the bank. It is not the corporate debtor's obligation. Hence, this will not fall under the moratorium protection. A landmark judicial interpretation in this case was Mitsubishi. There are few case laws. All of them have similar. They have set down a similar principle. In case of Mitsubishi Heavy Industries versus Pongeloid, the NCLAT principal bench ruled that PBG are independent contracts, not part of corporate debtors' assets. Moratorium does not apply, and there was no fraud or injustice which was proven to justify any restraint. So the only case where you could appeal against performance guarantee or financial guarantee invocation is in case of fraud. Typically, NCLTs do not would not entertain. That is the most common argument being taken against invocation of guarantees. However, proving a fraud is extremely difficult. So, unless a fraud or injustice has been proven, no restraining order can be obtained. A similar case was in case of WBSC versus PNB, and where here there was a security deposit which was given, and whether the uh, invocation of bank guarantee for what was permissible. A similar principle was laid down that BG can be invoked, and it is not considered as a preferential transaction. While also ensuring that you cannot have two claims. You could not, once you claim the amount from bank guarantee, then your claim amount has to automatically get reduced, or your, yeah. Another case in case of Bharat Aluminum Company versus JP Industries and Clad Principal Bench. Uh, a similar principle was laid down that guarantee can be invoked. Assets of the bank are distinct from that of the corporate debtor, and hence moratorium cannot be invoked for this purpose. And section there has been an amendment in 14th subsection 3 clause B, which exempts surety in a contract of guarantee to corporate debtor from moratorium. So guarantee given by a personal guarantor, corporate guarantor, that is can be separately invoked. Sure. Another case, in case of Gale versus Rajiv Manayar and others, NC NCLAD principal bench judgment, uh, for similar case of performance guarantee, and the RP moved to stay the invocation of the PBG. However, the stay was not allowed, and Gale was allowed to invoke the guarantee, and it was held that the guarantee could be invoked in the full or in part as per the contract terms. So we discussed on the invocation of LCs, bank guarantees. Now we come to what happens to the letter of credit money, margin money, or the bank guarantee margin money. Typically, the corporate debtor would place some margin, which is insisted by the banks when a guarantee has been issued. Whether the once the margin has been placed, whether it remains the asset of the corporate debtor or not, though this asset gets disclosed in the balance sheet of the corporate debtor, whether in a true sense is it an asset of the corporate debtor or it has left its control, so it kind of becomes an asset held in trust by the bank. So NCLAT has clarified in a recent case that margin money, even when held under an LC, or for that matter could be bank guarantee also, is not a security interest under Section 3, subsection 31 of the IBC. Hence, it will not become a part of the corporate debtor's insolvency estate. The courts have held that margin money has trust-like attributes. Once deposited, the control effectively transfers from the corporate debtor to the bank, and hence the corporate debtor loses proprietary rights over that margin. Post CRP initiation and resolution plan approval also, banks can invoke LC and appropriate margin money independent because it's independent of the corporate debtor's estate. So this was a recent case last month where NCLAT, the facts of the case were that the CD had to keep term deposits as margin for its BGs with the bank, and the BGs were invoked before CRP, and the bank had adjusted and appropriated the margin. So let's say if the margin is 10 rupees, guarantee is 100 rupees, bank would take 10 rupees from the margin, make the payment of 100, so 90 goes out of the bank's sources. In this case, the resolution plan was approved, and after the approval of a resolution plan, the resolution applicant noticed that bank had appropriated some amount towards the margin money. The bottom margin money was that they had appropriated when the guarantees were invoked, and they sought an order from NCLT to reverse the deduction, and the amount should come back to the corporate debtor. While NCLT ruled in favor of the SRA, the UNCLAT reversed the decision. They said that bank guarantee is not a security interest under Section 3, subsection 31. Margin money held in trust ceases to be the asset of the corporate debtor. And while an approved resolution plan binds everybody, the claims which were admitted earlier, they cannot be disturbed. And hence this order was reversed. And it was held clearly that the margin money would be the bank's property only. Now, this principle, does it apply only in case of the guarantees or LCs being invoked before CRP or even during CRP? I think there are, it has been held that even during CRP, if there is an invocation of guarantee or LC, then the margin money which is there will still not, does not have to, that can be used by the bank to make the payment, and this even after initiation of CRP, it is not the corporate debtor's asset. If the guarantee is returned, the obligations are over, then the margin money will flow back to the corporate debtor. However, in case of invocation, it will be used, margin money will be used to make the payment, part of the payment of the pay. Another case, Rajendra Prasad, who was a liquidator of KVK Nilachal Power versus Mahanadi Coalfields. And here margin money was deposited with the bank, similar case where to issue the PBGs. And during the liquidator, the guarantor invoked the PBGs. So sorry, the beneficiary, there's a typo, beneficiary invoked the PBG and the liquidator sought a return of the margin money, but NCLT denied the request. Uh, and this was upheld by the NCLAT, saying that it does not constitute a security interest under Section 3, subsection 31, or the moratorium will not kick in this case. So, yeah, so this principle has been very well established now. Another case, in case of Edelweiss ERC versus Commissioner of Customs. Whether the but typically you'll give guarantee where you do a zero duty import. You'll give some guarantees to the customs department whether the customs department is entitled to enforce these guarantees. Does the because the obligations of doing the exports have not been fulfilled by the corporate debtor, and I think this the principle also has been well established that department can enforce these guarantees. GVL Agro case, where a similar case where the RP asked banks to reverse the appropriation of LC margin money, and while NCLT Allahabad bench agreed, and they said that it is an asset of the corporate debtor, which should be protected by the moratorium. However, UNCLAD reversed this decision and held that the amount of margin money during CRP can be appropriated by the banks in case of an invocation. So now we come to classification of some other principles which have been laid down by some recent judgments. Recently, the High Courts held that a classification of fraud by the banks have to follow the principles of natural justice, in the sense that if the banks choose to classify a particular account as fraud, they have to give the some underlying documents or the forensic audit report, their observations to the borrower, invite their comments, provide them an opportunity of rebutting them or giving their arguments. If those principles have not been followed, then the classification of the account as a fraud would be held to be null and void. And there were some cases where the banks were reminded. So the strict adherence to RBI directions is mandatory. Banks were reminded that fraud classification is not a discretionary move. It must follow the strictly the RBI master directions, which meant that issuances of notices, giving time for responses, all those things should be done. And only after that, the classification as fraud could follow. No, there could not be any shortcuts. There were some legal doubts whether once the moratorium gets initiated, CRP gets initiated, moratorium gets kicked in, whether the banks are restrained from classifying any account as a fraud. And the argument for this was that if you classify an account as a fraud, one is that it is it is whether it is a legal action which is barred by section 14. It used to be argued that it's a legal action and hence could not be done. And the other commercial argument for this was that if you classify an account as a fraud, it would discourage the incoming investors, or it will mark down the value of the corporate debtor. So a practical thing which was being followed earlier, because all the stakeholders would take a cautious approach, was that you would defer classification to avoid any litigation risk. However, now this principle has been settled. In case of so then the Rulta case, it was so just we'll cover a few cases where the classification as a fraud was done without giving due opportunity to the borrower. So one of the cases is Ratul Puri case versus Bank of Baroda, Delhi High Court held that fraud tagging has serious consequences and hence it must comply with natural justice principle, and hence any action which did not conform to that would get invalidated. Another case where Gujarat High Court held that the borrower must be given a copy of audit report before the classification, must be given a reasonable opportunity to represent, and a reasoned order must follow. Since none of these were followed in this case, the classification was squashed. So a reasoned order, due process, notice, hearing, all those is a mandatory thing to be followed before classification of any account as fraud. Similar case in case of SBI versus Rajesh Agarwal, the Supreme Court case of 2023, same principle has been reiterated that procedural safeguards have to be there, and anything done without that is unconstitutional. So yeah, there's similar case, so we'll skip this. Yeah. Okay. Uh, let's go to the next slide. Then we'll come back. Union Bank of India versus Rolta. This is a recent case in July 2025. In the case, in this case, the issue was whether the banks were allowed to classify an account as fraud during the moratorium, and it was held that fraud classification is just an administrative action. It is not a recovery action which comes under the ambit of Section 14 or which is restrained by Section 14, and hence such a classification does not violate Section 14 moratorium, and it affirmed the bank's right and the regulatory duty to classify the account as a fraud even during CIRP. So it has been so it the key takeaway is that it is not a coercive action. Classification of an account as fraud is not a coercive action. It is part of the regulatory duty of the banks, and hence that needs to be done. Let's go back. Yeah. So we covered these principles that it's an administrative in nature, not an enforcement action. It helps the banks mitigate their systemic risk and comply with the regulatory duties. So banks are well within their rights to classify the account as a fraud. Now, an important commercial aspect which comes into play is whether it dampens the investor sentiment when an account is classified as a fraud, because the investors do not want to be caught in a quagmire of litigations at a later phase, and also that this has a reputational risk. I think the Section 32A of IBC is clear that any past actions or any regulatory action, there's a clean slate principle which is there, and hence any incoming investor would not get affected by any such classification. This is a similar thing for willful defaulter, that whether a classification of a company as a willful defaulter, whether that will be hit by Section 14 or Section 96 of IBC. It has been held that the moratorium will not hit the classification of companies or people as willful defaulters even during the CRP. So IBC's shield will not cover regulatory reach. Moratorium is not a cover for willful defaulters, and regulatory process should go on unhindered during the CRP. That is the key principle. And regulatory objectives, the objectives laid down by the RBI in its classification of accounts as fraud or as willful defaulters, there are systemic objectives, goals, and that is to create a disincentive for the borrowers, for the people to against defaulting, and hence a willful defaulter designation serve as a systemic goals for curbing moral hazard by alerting lenders to risky borrowers rather than aiding debt recovery. So this is not for the purpose of debt recovery, and therefore it would be outside the protective cover given by IBC moratorium. Of case law, in this case, the facts of the case were that a former director was declared as a willful defaulter based on a transaction audit report, which was deemed unreliable. by NCLT, and he was denied access to documents and was not given an opportunity of being heard. And the issue involved was whether a reliance on a transaction audit report, which was considered unreliable by the NCLT, is fair, and whether not giving the documents to the erstwhile director was against the principles of natural justice. And the Bombay High Court, in this case, held that transaction audit alone is insufficient, and the willful defaulter committee should rely on a robust proof, not just a transaction audit report. And the petitioner was entitled to these documents. The key takeaway, repeating the key takeaway, that procedural fairness is a must before classifying any account as a willful defaulter or a fraud, even whether it is within IBC or outside of IBC, or whether during IBC process or outside of IBC process. Okay. A similar case where Calcutta High Court also held the March 2024 case, and that willful defaulter classification, it was held that can be applied even without NPA status. Willful defaulter proceedings are not recovery actions, not barred by IBC's moratorium. And however, the procedural aspects have to be followed, and the banks cannot take a plea they cannot classify an account as a fraud or willful defaulter without following the necessary safeguards which have been prescribed. So procedural fairness is extremely essential. So a similar principle which was laid down in Delhi High Court. Yeah, okay, let's go ahead. I think here also, in this case, Gauri Prasad Goenka versus SBI Calcutta High Court held that Section 14 does not bar, so a similar principle has been laid down. And a willful defaulter proceedings against directors or guarantors that can continue, and Section 14 will not come into play here. Another principle which has been laid down is that the personal guarantor's obligations or a corporate guarantor's obligation will continue even when the corporate debtor goes under insolvency. And this the personal guarantor of a corporate debtor also has been brought under the ambit of NCLT. Reform was carried out under, and before this reform, creditors typically pursued personal guarantors under DRT. But by 2019 notification, insolvency proceedings against personal guarantors can be handled by NCLT. And the shift was to for this objective, that integrating personal guarantees into the same framework and aligning with them with the corporate debtors under a single tribunal will ensure that there is a cohesiveness, and jurisdictional fragmentation is avoided. And this was challenged in the Supreme Court. However, Supreme Court has upheld the validity of this notification in case of Lalit Kumar Jain versus the Union of India, and has reaffirmed that this move falls within the government's legislative authority. It emphasized that a resolution plan for a corporate debtor will not extinguish the liabilities of a personal guarantor. But this is another case where when there's concern the enforceability of a personal guarantee after the approval of a resolution plan, and here the personal guarantor had executed a fresh guarantee following the plan's approval. So the key question involved here was whether the approval of the resolution plan discharges the personal guarantor from the liability, especially when the fresh guarantee was executed. The NCLAT while the NCLT ruled in favor, NCLAT dismissed the appeal, and it affirmed that the personal guarantee remains enforceable even after the approval of resolution plan, and that the personal guarantor's liability is independent and not discharged by the corporate debtors resolution process. Here also it was held that personal guarantee is another case where it was held that personal guarantees executed after resolution plan, they would remain enforceable, and creditors can initiate insolvency proceedings even after the resolution. So the same principle has been laid down in multiple cases. Go ahead. We discussed this case of Lalit Kumar Jain versus the Union of India. This was the landmark case which reaffirmed this principle. Another case where the same principle has been laid down. Yeah. Well, we come to filing of writ petitions. So, under the Constitution, Supreme Court and High Courts hold the authority to issue writs, legal instruments like prohibition, mandamus, quo warranto to uphold the rule of law. And Article 32 empowers the Supreme Court to enforce fundamental rights, making access to it itself a constitutionally guaranteed right. And Article 226 deals with the high courts, and they have a broader jurisdiction that they can enforce not just the fundamental rights but also the legal and statutory rights, and even act when violations occur outside their immediate territorial limits, making them more agile and accessible in protecting rights. So under these two, Article 226 and Article 32, powers, the writ can be filed before the High Court and Supreme Court. Now, the key question which comes in is that whether when there is insolvency which has been initiated, then just go ahead next. Uh, we'll take this case whether when the insolvency has been initiated, whether a writ can be filed before the High Court or the Supreme Court. So the principle is that if the writ is relating to any recovery action, then well, it comes under the bar imposed by the moratorium, and hence that cannot survive. However, if it is to do with other aspects, then the writ can be filed. Let's take this case law in case of Canara Bank versus Deccan Chronicle Holdings. Here, Canara Bank had initiated insolvency proceedings against Deccan Chronicle, and the matter was admitted. And the issue to be decided was whether the moratorium under Section 14 affects the jurisdiction of the Supreme Court and High Courts to entertain writ petitions under Articles 32 and Articles 226. The NCLAT held that the moratorium does not affect the power of High Court under Article 226. However, suit filed before any High Court under its original jurisdiction, which are money suits or suits for recovery, cannot proceed after the declaration of moratorium under Section 14 of IBC. So, any suits for recovery against the corporate debtor that cannot continue after moratorium. So the key takeaway here was that writ jurisdiction under Article 32 or 226, they remain intact despite a Section 14 moratorium, and thereby the supremacy of constitutional remedies has been upheld. It has been emphasized that these constitutional powers cannot be overridden by statutory provisions like IBC's moratorium, and hence the fundamental rights are protected. Okay. So we briefly touched upon this that RBI and the central government have the powers to initiate uh, insolvency against financial service provider, And initially, IBC excluded financial service providers from the definition of corporate debtors. And Section 227 of IBC, there is an interplay between IBC and the RBI Act. Section 227 empowers central government in consultation with the financial sector regulators to notify categories of insolvency and liquidation under the IBC in a manner that may be prescribed. And the FSP rules 2019 were notified in 2000 in 15th November 2019, whereby systematically important financial service providers, NBFCs, and housing finance companies with asset size of at least 500 crores were notified against under these rules. And the appropriate regulator, typically RBI, will be the authority to initiate CIRP for such notified financial service providers. We have seen the cases of, go ahead, the in Dewan Housing, Sri, two arms of Sri, and Reliance Capital. Move forward. Some important principles that license or registration authorizing financial service providers to provide financial services will not be suspended or cancelled during the interim moratorium, which means that their ability to do the business during CRP or liquidation will continue, and unless the regulator has a different view. And the interim moratorium will commence from the date of filing of the application by the regulator until its admission or rejection by the NCLT. So here the interim moratorium comes into play, unlike other cases where the moratorium starts after the admission of the case into insolvency. And the third party assets, funds held in trust are protected, so the depositors' money and all that has a protection, and moratorium will not apply to these assets. Uh, just taking this forward, the regulator has the power to propose individual who is appointed as an administrator under the CRP of these financial service providers. NCLT appoints that, and regulator can also constitute an advisory committee within 45 days from the insolvency commencement date, who and that advisory committee can assist the administrator. And for approval of the resolution plans, regulator also needs to give a no objection certificate, no objection, because the management which is taking over should also fulfill the fit and proper criteria laid down by RBI. So the interplay in the earlier case is that uh, uh, the insolvencies of the financial service providers is also important from the standpoint of providing stability, reviving these troubled institutions, and IBC acts as a mechanism to lay down the procedural aspects. One important point, which it's a kind of it's a sore point which needs to be addressed, and is the intercredit creditor arrangements. Typically, when the banks lend, they lend basis collateral security, and on a single asset, there could be different lenders lending on the same asset, or say a pool of assets, and the assets could be a fixed, floating, could be current assets, could be fixed assets, and different assets, different banks or financial institutions would have different priority of charge. Somebody could have a first charge, somebody could have a second charge, and there are intercreditor arrangements which govern which creditor, if they in case of default, how the security value gets paid to the creditors. The priority is determined by these intercreditor arrangements, and this is broadly governed by the Indian Contract Act and Transfer of Property Act, where judicial precedents have supported honoring the creditor priority in case of payouts. So this is one of the fundamental principles in lending, and where the priority of charge, and this has been in place for several ages as such. Now, IBC's approach and judicial interpretation uh, for this. Under IBC, the payout mechanisms under Section 30, where resolution plan is approved, or 52 or 53 under liquidation, and they formally do not recognize the creditor hierarchy. And typically, all the secured lenders, whether they hold a first charge, second charge, or a subservient charge, they are treated as equal at the payout stage. And there were certain rulings for in the case of SECB versus Raheja TDB versus Anil Goel, where the priority of claims has been dismissed. And it has been argued that there is only one class of creditors, which is the secured creditors. So within that, everyone is treated as equal. Now, 2024, there was a Supreme Court judgment which conflicts the earlier rulings. And in fact, the TDP versus Anil Goel judgment has also been stayed, and the Supreme Court is considering that judgment. And however, this issue has to be resolved, because the principles or usual banking principles, or the usual principles under the Contract Act, that should also be embedded well with IBC, and that is not the case currently. Go ahead. So, legislative reform here is a must, because ignoring the intercreditor priority uh, disturbs the entire lending ecosystem, and it does not align well with the banking laws, or even all the international systems. So that is something where a reform is a must, or some changes need to come in to address this issue, and an amendment to Section 53 is a must. So now we come to the some key takeaways, that uh, s- uh, even during CIRP, just jotted down a few. Even during CIRP, banks can pursue guarantors independently. They can classify accounts as fraud, or enforce independent contracts like LCs and PBGs. And they can also appropriate the margins. The fraud reporting obligations of the bank under RBI circulars prevails even during CRP, and IBC cannot be used as a shield here. The commercial wisdom of the COC versus the regulatory duties under RBI PMLA, they have also been well established, and precedents have made it amply clear that regulatory obligations cannot be overridden by insolvency. Though 238 is a non-obstant clause, a certain banking laws will continue to prevail in context of personal guarantees, PMLA, LCs. So these principles have been laid down, and yeah, as a conclusion, the banking laws and IBC laws, they have synergies. They work in tandem. They go hand in hand. And while the banking laws safeguard the systemic integrity, contractual sanctity, and financial discipline, insolvency focuses on the resolution, and hence lends a hand in restoring the financial stability and adding towards the economic stability. So yeah, so that is all from our side. Thank you so much for the patient hearing. If there are any points for discussion, would be happy to take them up, or else we could end the session. Really, any closing remarks, so we can go ahead and end the session? we will circulate this presentation. We'll send it out to you, and then you can disseminate it. Not there, right? So I would thank everyone. I again thank everyone for the patient hearing, and hope that this session was of value. Thank you so
Thank you,
much.
Ashish.
Thank you.
Thank you,
Thank you, sir.
Thank you. Thank you.
But yeah,